Welcome back to the Legal Alternative Podcast with me, Sam Pawson. Join us over by Nils. Morning, Nils. How are you?
Enjoying sunny Leeds, Sam.
I know.
Sunny Leeds, it's fantastic.
It's the one drawback of now we're in a video format, Nils. I think I might have been in shorts and t-shirt, but since we're being filmed, I thought I'd remain professional and keep my jacket on. No, it's lovely, lovely sunny day. An exciting pod coming up, I think. What have we got coming up today?
So, usual what's in our inbox. I'm going to be talking about some immigration law changes. Then we're going to discuss a fantastic achievement by a colleague as
Yep.
well as what we've been up to. And then we've got a very interesting question at the end from one of our listeners.
We do. I think I'm up first on the inbox. Now, when I say inbox, phone, stop on the street, comments from people I've not heard of in 5 years. We're talking Supreme Court decision on the Equality Act, Nils, as you probably expect. It is dominating my world at the moment. So I thought it would be appropriate for us to put our spin on it. And as we always want to do on the podcast, look at that alternative, because again, I think more than ever, there's been a lot of reporting on this, and I think a lot of this actually has been potentially, and I'll be very careful with my language, but a lot of it's been inflammatory and potentially misleading over the actual judgment. So I want to go back to basics, pick through the actual judgment itself, and then try and go through some of the kind of impacts on for our listeners. So I think as most people will be aware, Supreme Court ruled just over a week ago on the purpose of the Equality Act, all over the definition really of a man and a woman relating to the protected characteristic of sex. The ruling came as a result of a challenge by a group called For Women Scotland, who were an advocacy group who challenged a ruling in Scotland about the definition of woman in result for board appointments. There was a case where someone with a gender reassignment certificate applied for a role as a woman. That was then ultimately challenged. What the court's decision was, and has obviously got a lot of the political and press attention, is that when we refer to a protected characteristic of sex, that only refers to someone's biological sex. So where we would have someone who was either obviously a transgender man or a transgender woman, they wouldn't be protected under that protected characteristic of sex, because they obviously were not a biological man or a What I think that has resulted in is a lot of reaction and a lot of debate, which has resulted in the view, and not saying this view is correct at all, and it isn't in the law, that people who are either transitioning or have transitioned do not have any protection in the law, which is absolutely untrue.
I was going to say that's a protected characteristic in itself, isn't it?
Exactly. So you've hit the nail on the head, is that none of this decision has done anything to rule that there's no longer a characteristic of gender reassignment, or indeed people going through that gender reassignment process still would have protection from their biological sex as well. Without getting too complicated, there is also protection under wrongly perceived sex. So there is protection, and I think that has caused a lot of inflammatory comment and a lot of misreporting. There is no protection, or people aren't protected. The decision itself, as I say, is quite fact sensitive, but does have an impact. And I'll come in a minute to the potential impacts and really the queries I am getting, which is quite complicated. But I think that is the main headline for me, is there is protection either through discrimination through perception or the standard protected characteristics of gender reassignment. The difficulty, and when we're talking about what's in my inbox, since the ruling, we've had some further guidance, which, to be honest, I think is even more complicated, the issue. So the question I am getting a lot at the moment is about facilities, single sex spaces, which is very difficult, and I know goes into your world slightly as well, in terms of health and safety and facilities. So we are having questions over use of facilities, and can transgender employees use single sex facilities. What the ruling suggests, and some guidance that I'm going to quote from the Equality and Human Rights Commission, has published guidance to say, which essentially saying that transgender employees would be prohibited or should be banned from accessing single-sex spaces, which I think practically does cause some concern. And I have questions of why that guidance would be so strong, because that guidance is then ignoring a protected characteristic of gender reassignment. And we do have these difficult cases that we've both come across where you have two protected characteristics that potentially compete against each other. And that is always a very difficult and delicate legal matter. And therefore, to be so carte blanche with your guidance to say that they are banned or prohibited. The guidance then talks about how, organizations should attempt where possible to provide, additional facilities. The real difficulty for a lot of organizations that we act for, they're not having, 4 or 5 different toilet facilities, for example, that would be appropriate for men, for women, obviously on the biological definition, for disabled users, for transgender users. So it is a real delicate situation, and one, I think, to be honest, there isn't definitive guidance, and I really think from the government there needs to be some guidance given, because we have two absolutely competing protected characteristics here that a simple judgment that rules on biological sex doesn't cope with. I don't know. Again, you've got a lot of experience in that area, Nils. I don't know if on facilities whether you've got any views on that.
I'm trying to remember. I think it might have been ACAS that talk about a transition plan, and I think as part of that transition plan, their recommend, and I might be wrong, it might not have been ACAS. Their recommendation is that an individual who is either transitioning or has transitioned should use the facilities with which they identify. Would directly compete again with the guidance that you've just referenced.
The guidance of the judgment, and that is the difficulty, because that when we are purely referring to biological sex, whether someone has transitioned or not doesn't matter. So we are then, you're either as an organization, if you follow that judgment to the law, would require a transgender woman to use male facilities. So unless there is a way of having additional facilities, which again I think causes problems. I've seen some organisations say, well, could they use disabled facilities? Again, that equally causes problems. So I don't think I want to come to this podcast to say I have the answers. What my view is, and from what the case has been presented, is that we are missing a lot, and the narrative that is seemingly being used to push biological sex, that's fine, but you are still ignoring other protected characteristics. And until there is a way and some guidance through that, this is going to cause real problems for organizations. The advice to any organization for me has to be, you have to use your judgment. These are very sensitive situations, and I think you need to speak to your workforce. And wherever possible, this idea that seems completely lost with the public at the moment of getting kind of agreement and consent. These cases get so much press attention. In reality, for organizations, they happen very rarely. And if they are approached with dignity and respect and understanding, I think that will hopefully get to the across most issues. If it doesn't, then you are in real difficulties, and absolutely we need further advice from the government.
Yeah.
So that, again, I think will continue to dominate the agenda for a while. We'll obviously, any updates we do get, we'll put them across on the podcast. But yeah, difficult one, and we'll continue to update.
Absolutely. Slightly change of tack from me. So just a pure sort of economics update, really, in terms of the immigration fees. We talked a little while ago about how it was going to be harder for organisations with some of the changes that the government have made to go through the skilled worker route. And from the 9th of April, UK immigration fees actually increased. So it was and I'm going to read this out because I can't learn this off the top of my head.
Yeah.
The Immigration, Nationality and Passport Fees Amendment Regulations 2025 was passed. And the new fees took effect at 9 a.m. on the 9th of April. So the cost of a certificate of sponsorship for a skilled worker has risen by 120%.
Wow.
from £239 to £525. That's quite a big increase, although not a huge increase in the overall context of the cost of a visa, perhaps. The electronic travel authorization fee has risen from £10 to £16. That's for people wanting to come to Britain as a tourist. I've seen that most, in fact, every time I've been to America, getting an ESTA. So that's gone from £10 to £16. That's our equivalent. And naturalisation as a British citizen, going through that process, that fee will go up to £1,605 from £1,500. The sponsor license fee will also increase for large sponsors from £1,476 to £1,579, and for small sponsors, a small increase from 536 to 574. So rises across the board. And there's also been changes in relation to how the government now defines a small sponsor. So they've changed the goalposts or the boundaries in respect of the thresholds. So there's 3 tests for a small sponsor. Number of employees, that remains at 50. Turnover has changed from 10.2 million to 15 million, and your balance sheet total from 5.1 million to 7.5 million. So if you meet 2 out of those 3 criteria, you're classed as a large employer. So there's been increases there. If you are now classed as not a small employer, and this is a critical update really for today, you have to let UKVI know via the sponsorship management system. So there isn't going to be some magic tool at UKVI's end that will automatically update their system that you are a large employer now. You have 20 days to update, make that change. So that came into effect from the 6th of April. So if you haven't done that, that's something that you need to attend to.
So in terms of the, I'm not sure if you'll know the answer, Nils, but just your opinion. When we're talking about increased fees, is this a deterrent? Is it aiming as a deterrent for people to apply for licenses, to make the process more costly, or is this a funding the resource?
I honestly don't know. An MP who I know, who should remain nameless, he said that all parties agree that immigration needs to be controlled. It's just at what level and how you do that. In terms of a deterrent, it's not a huge deterrent. So a certificate of sponsorship would be £300. It might be that the level of cost that UKVI has been charging means they need that additional, that difference to now actually service people better, perhaps. So I don't think it's a huge deterrent if that is the case. But if you look at the whole measure of packages that have been passed, then there is no doubt it's actually harder. Whether that's intentional or not, obviously for the government to answer. They say, and we discussed in in previous podcasts, this was about cracking down on rogue employers. When you look at the full suite of measures and the package that have been passed, it is harder.
It is, as you know, Nils, and we talked about it. I've involvement in social care sector, and it's the increases on that threshold is going to be very difficult in an already struggling, and in terms of being able to afford the cost of staff compared to the funding they're getting is putting real strain on that sector. So something to consider the impact. I'd hope that some kind of consideration has been given to that, but we shall see.
Absolutely.
At the office, Nils, what you mentioned our dear friend Paul Marshall. Do you want to update the listeners as to what he's been up to?
We'd like to congratulate Paul, who's an avid listener.
He is.
He supported this pod the whole way through, and we'd like to congratulate him on completing the London Marathon in an excellent time and raising some really great funds for a worthy cause as well. So well done, Paul. Really pleased and proud of your achievements. Fantastic achievement. And it was hot on Sunday as well.
It was. 2 weeks before my own marathon, which is coming up. But Paul, I know he's been trying to get in, hasn't he, for 10 plus years. So no, really, really pleased for him. As you say, fantastic time. Knowing Paul, I'm sure he's been roared on by the spectators will have helped him. So no, absolutely fantastic achievement. We'll be seeing more of each other than the pod next few weeks. So as time of recording and time of release of the pod, I think next Thursday, the 8th of May, we're both heading the stadium for your annual mock trial? Do you want to let people know kind of what to expect?
Yeah, really excited again to be working with Lighthouse on this.
Yeah.
A mock trial showing what happens if it all goes wrong, basically, and there's a health and safety breach and you find yourself in court. So really looking forward to that. We've got a good number of people coming, which is really exciting. So excited to meet some existing clients and some clients of Lighthouse as well that we've not come across before.
Yeah. Questions from socials, Nils. I think you've had a question about something I spoke about.
Yeah.
So do you want to share the question?
So it's, how does the neonatal leave that we discussed a couple of weeks ago, how does that interact with the family-friendly rights that individuals have?
Yeah, I think a good question, and one I've had directly as well, and clients have emailed me. So I'm glad the pod is getting out there, and people are having questions. So good to follow up. I think the confusion has come round, as Nils, as the question suggests, between when does maternity leave start and when does neonatal leave start. And I think I probably alluded to, but I think it would benefit for me for going in a bit more detail of the practice and what might happen in practice, because I think we talked off there about a reality and what the law says. So the law relating to neonatal leave is that it can only be taken after a period of maternity leave. Quite understandably, I think a number of listeners would imagine, obviously, very serious neonatal issues around birth. If you have a premature birth or difficult birth that requires neonatal leave, that would kick in immediately. What the law actually says is no, for a mother. I'll come to another parent in a moment, but for the mother, the law still remains that when we talk about maternity leave, that is triggered automatically by the birth of that child. So if this is a premature birth, even if the maternity leave was intended to be taken, a few weeks or months after, the birth triggers that to start. So you would have a period of maternity leave starting from birth. That then, by law, there is a period of compulsory maternity leave that has to be at least 2 weeks, 4 weeks if we're working in a factory setting. And that would have to take place. What could happen then, but as I say, in practice, I think it will be difficult to see, is a period of maternity leave could then be ended or curtailed. And then if there was then still complications that required neonatal care, and I won't go for the definitions I did last year, what amounts to neonatal care, but then a period of neonatal leave would take place. What we talked about in practice last time is that what goes with neonatal leave is statutory pay, which generally is going to be less generous than maternity pay. So in practice for mothers, I think it would be unlikely why there would be any attempt to curtail maternity leave. I think it's going to be more applicable for either fathers or partners who are also entitled to that neonatal leave, because practically pay for paternity or adoption pay, or if you are a partner, is much less than it would be. And it would be equivalent to that neonatal leave. So that's what I probably see in practice. But I think we've had a lot of questions on it. So really important one to clarify.
Fantastic.
Good stuff. As I say, we will be seeing a lot of each other over the next few weeks, which is fantastic. We'll be back with the pod next week. So big thank you to you, Nils, and goodbye from me.
And goodbye from me. See you later.